We're here today as part of NCFA Canada and it's FFCON21, and we're talking to SEC Commissioner Hester Peirce. Thank you for joining us, Commissioner.
Alex, it's really wonderful to be here as part of FFCON. And I have to start with my standard disclaimer, which is the views that I represent are my own views, not necessarily those of the Securities and Exchange Commission or my fellow commissioners.
Let's start right away with your digital asset safe harbor proposal that you put forward. You put out probably, I think it's almost 2.5 weeks, 3 weeks now, a new kind of tweaks to that safe harbor. Can you explain it a little bit further to the audience here?
Yes, the goal of the safe harbor is to give projects a 3-year runway where they don't really have to grapple with the issue of whether transactions in the token are securities transactions or not. So a project would be able to do a token distribution event, would provide certain disclosures to purchasers and to the wider world about what their plans are and kind of what the token economics are. And then they would update those disclosures periodically, and they would certainly, any material changes they would make public. And this would give them time to build out the network. The idea is to get it to a point of functionality or decentralization. And then at the end of the 3-year period, they would have to get a lawyer to do an exit report for them, essentially saying we've reached functionality or decentralization. And then at that point, the securities laws wouldn't apply. If you couldn't get a lawyer to give you that kind of a finding, then you would have to register the tokens as securities. So the idea is to balance the interests, which is one, making sure that token purchasers are getting information they need, but two, allowing these token networks to move forward with some sense of certainty. There still is ambiguity, and I think that that's one of the pieces that we're getting feedback through GitHub, and we've gotten some great feedback. And that's one thing that people have raised with me, is that they still want more certainty on the exit side of things. But I think that this is a good step forward to provide some clarity.
One of the questions people are probably asking is that they haven't decentralized enough, or not enough tokens are out there, and they find that they are a security. How long do they have to kind of get things in place?
Well, I think the goal is that people will have this 3-year period, and if you realize at 2 years that it's unlikely that you're going to meet the standard at 3 years to be a to have this outside of the securities laws, then at that point you really need to start planning. So I think that that's kind of incorporated in that 3-year period. There are certainly issues with treating tokens as securities under the securities laws. And so the goal, I think, would be for most of these people who are planning to take advantage of this safe harbor, their goal would be at the end of that 3-year period to be outside of the securities laws altogether. But I think, much the same as we've seen in some enforcement actions where the end result has been, that there's a registration requirement, that's sort of the model that we're thinking of here. One final thing about, just to clarify on the safe harbor, that it is my proposal.
Yes.
And which means it's not an official SEC proposal. I'm seeking feedback. My goal is to present it to our new chairman, Gary Gensler, and have him take a look at it and see whether this is something that he could get behind or whether there's something similar that he would be interested in. And so the more engagement I get from people now, I think the more fully fleshed out that proposal can be when I present it to him.
But let's talk about how a proposal becomes a policy that's then moved into a rule and how that works in the commission.
Well, I think that's a great question because it can be a bit of a black box at the SEC. And what I did here by making a proposal of my own is relatively unusual. Typically, the way proposals get developed is the chairman. So the commission is made up of 5 commissioners, one of whom is chairman, and that's now Gary Gensler. And so the chairman has responsibility for the agenda of the agency. And he sets out an agenda and then directs the staff to work on those agenda items. And so typically that's how a proposal would come about, is that he would direct the staff would prepare a proposal, which we then as the commission would get involved in editing and refining, and then that we vote on as a commission. It goes out for comment. We get comment, comes back in, the staff reviews all of those comments and takes into consideration the feedback that we got. And then, if we're going to move forward with a final rule, that works through the commission process the same way, where we're involved in working on it. And that can be a very long process. It can take a long time because we want to make sure we give commenters enough time to weigh in. So if my safe harbor were to become a rule, it would have to go through that proposal process and then would have to go through the adoption process.
So the timeline, just so that people understand, we're not talking about weeks. We're not talking about even just a couple of months. Can you give people a sense of that timeline?
So typically when we put out a proposal, it'll go out for comment 30, 60, 90 days. 90 days, I would say, is probably pretty standard, but it's 90 days from publication in the Federal Register. So once we adopt something, we put it up on our website, but it doesn't become the comment timeline doesn't start ticking until it gets published in the Federal Register, which is just the compilation of all the proposals and adoptions coming out from all over the government. And then once the comment period closes, we'll still accept comments past that deadline typically, because it takes a while to compile the comments and think about them and develop a rule for adoption. And so that process is likely to take some months as well. It does depend a lot upon the rule. There's some rules that go out for proposal and we don't act on them for quite some time, but there are others we could get the whole thing done within a year, for example. 6 months would be very aggressive to get a rulemaking done. The one thing I will say is that Gary was the chairman of another agency, the Commodity Futures Trading Commission, and he based on that experience, he does like to move fast. He's very he's got a lot of energy and likes to get a lot of things done. So I don't know what timelines will look like under Chairman Gensler, but I would anticipate that they will not be extended, but that they will be on the shorter side of things.
Well, that's great. Let's talk about Bitcoin ETF rules. A couple of weeks ago, a hold was put on any ETFs for Bitcoins being approved by the Securities Commission, so the Commission can take a further look at it. Can you explain kind of what sort of things that the Commission will be examining internally?
Well, I think the hold to which you're referring was with respect to one particular application, and it maybe a hold. I would describe it more as an extension of our timeline, and I don't think that that's so unusual. So I think there are a couple things that are important to understand about the process with exchange traded products in the U.S. One is that you come in and you're discussing with the staff of the agency, and our staff is about 4,500 people, and we have several divisions of our agency that could get involved in these exchange traded products. And so sometimes before you even file an application, you've had quite lengthy discussion with the staff, and then you file, and then there's a timeline for consideration. Most of the determinations on exchange traded products are made at the staff level through delegated authority from the Commission. Sometimes they come up to the Commission and we ourselves approve or deny the application. And right now we're seeing a number of different applications in front of the SEC, and there's been, a lot of interest for a number of years now on exchange traded products, but I would say now we have quite a few in front of us. Because we have a new chairman, 2 weeks, he's been in the job 2 weeks, I would imagine that he wants to get up to speed on everything that's going on at the agency, including the process with respect to exchange traded products. Although, as I say, a lot of those decisions get made without the Commission's involvement. In terms of things that we're looking for, this has been a very data intensive process. As different iterations of exchange traded products come in, the staff asks a lot of questions. There's a lot of back and forth. Some of that is happening in the public comment file, because when an application is noticed, other people can write in, and so you get lots of really good information. The staff is looking for data about the underlying Bitcoin markets, for example, and how prices are determined. How influential is the futures market in the spot prices for Bitcoin? Those are the kinds of questions that are getting asked. What are the supervisory arrangements over different spot markets? Those are issues that are being looked at. And so it's a very data intensive process, and I don't think it's surprising that it has taken some time, although I've been quite outspoken about the fact that I think maybe we're applying a standard here that's quite different than what we would and have applied in the past.
NFTs jumped from being a niche type product with a niche type group to one where it's more broadly talked about by other groups as being a way to raise capital. Where do you feel that kind of fits in the continuum of different products that are available in the market?
I think it's really hard to generalize for NFTs because there is such variety across what they are. I mean, it ranges from, right now, there's a lot of attention on artists using them just to sell their work and raise money. But there's also, I think, down the road, there's going to be consideration of how can NFTs be incorporated into our securities markets, maybe as a digital representation of a share. And so there's a lot of room between there. One can also imagine that there'll be groups of people who want to build portfolios of NFTs and sell chunks of those portfolios. Those kinds of things might start looking a lot like securities as well. And so I think it's one of these things where people need to be thinking about the securities laws as they're planning to do things with NFTs, but I'm not sure that all NFTs are going to implicate. I mean, I certainly wouldn't think that all NFTs will implicate the securities laws, but it's been an interesting development in crypto to watch, because I think it's brought a lot of people into crypto who otherwise probably wouldn't have, paid much attention, whether it's famous artists or, musicians. So I'm curious to see where this will take us.
Do you think like the Howie test, something that's applicable or something that needs to be adjusted to kind of the way that people are using these new instruments? Can you talk about the Howie test and just how Howie may still or still not apply?
So Howie is a now famous Supreme Court case in the United States, and what it was looking at is the SEC has a definition of security that's intended to be broad to capture any kind of capital raising event. So, when you do talk about capital raising, you better think about the securities laws. And so not only are things like stocks and bonds going to fit within the category of security, but this broader category, a more ambiguous category called investment contracts, is captured by that definition. And the Howie Supreme Court case looked at a particular instance to see whether or not it fit within the category of investment contract. In that instance, it was someone who was selling slices of an orange grove, but doing so with a promise that they would do the work, and all the investors had to do was invest the money, and there would be a common enterprise where their fortunes would all rise or fall together, but based upon the work of this third party, of the person who was selling the investment contract, not the investor. And so that is the framework through which we look at any kind of unusual, something that doesn't fit within the box of the typical security that you think about, but it's someone selling something with a promise to do the work to make it increase in value. And so that is what's being applied with respect to crypto to figure out often. I mean, certainly there are cases, we just talked about an NFT that could function just like a representation of a share in a company. That's clearly going to fall within the security basket, but there are also these other things that are a little bit more ambiguous where you're selling something, and this is what happened in the 2017 phase where people were selling things that seemed to come with this promise that all the person needed to do was invest, and there would be a promise to increase the value of that token. And so that's where the intersection with Howie has come in. Now, when I came to the SEC as a commissioner, I thought, Howie has served us really well over a long period of time, and I don't see a need to make any changes in this context. But I've thought a lot more about it, and I'm a little bit less comfortable, one, with how expansive Howie can be, so that it really could encompass the sales of lots of different things. And I'm not sure that that is the right balance. But I certainly have concerns on the crypto side, because I think that, and this goes back to why I proposed a safe harbor, I think that it's very difficult to do a token distribution event where the development team is promising to build a network, because that's what that's the whole plan, is to build a network, get network effects, get more people using the token. And so how can you walk the line of making those promises about building out a network without running into Howie and the securities laws? I think it's quite a difficult line to walk. And so that's why I'm looking to provide more clarity there. I think there may be other types of assets for which we could also provide clarity about how Howie interacts with those kinds of assets.
Do you think maybe guidelines would be more appropriate than kind of a rule-based approach?
Well, I mean, we are a principles-based. The whole reason that our securities laws have this broad definition is because a principles-based approach is going to better capture people who are trying to do capital raises and calling it all manner of things, but what they're doing is a capital raise. And so I'm certainly in favor of having a broad enough definition of security that we can capture anything that is a capital raise, regardless of what it's called. And so you're right. I think that guidelines tend to be a better way to go than having a very rules-based approach. But there's always going to be a tension, because when you have broader principles, people then really don't always know what they can and can't do. And so how do we get the balance right there? Because the other issue that I really worry about, and I think it's something to think about even in connection with the safe harbor that I propose, I don't want our rules to be so locked into any particular technology. They need to be technology neutral so that they can survive the test of time. And I think that's why something like an investment contract analysis under Howie is really a valuable thing to have, because it does mean that you can have this time and technology neutral way of looking at things, which is helpful. But there's definitely some tension there.
When you're talking about the digital asset safe harbor, I can see how you have the intention of it not being a security, but then it becomes one because it's not picked up. I think Howie still is applicable even to this day.
I mean, I think the one thing that makes it difficult is you can read Howie very broadly, so that even if you're selling a product, you're obviously doing it because you're trying to make money when you sell a product. And so where do you draw the line between when that product and the wrapper with which you sell it is being treated as a security or not? So I think of something like a fancy maker of fancy watches, right? When you sell that watch, you sell it with a promise that not only is it going to be a great timepiece for you, but you're going to be able to pass it on to your sons and daughters and grandsons and granddaughters, and it's going to be this asset that increases in value over time. And why will it increase in value over time? Because you, the company, are planning to develop a brand around that watch. And so is that watch then being sold as part of an investment contract? Are you buying it because you expect it to appreciate in value? And that's why I think, sometimes it is difficult to draw these bright lines, because you end up encompassing a lot of things if you have a principles-based approach, but if you draw bright lines, then people engineer around them. So it's a fun issue for securities lawyers, but not always fun for people who are trying to do something in a way that's compliant with the securities laws.
True, definitely true. SPACs seem to have gotten a resurgence over the last 3 years. The SEC, I think, rightly so, is taking a look at SPACs and how they're operating. Can you talk a little bit about the origins of SPACs and just how those blind pools have been having a resurgence?
Yeah, so as you say, special purpose acquisition companies have been around for quite some time. I don't know the exact date of the first one to be used, but they're very much having a resurgence in the last year. There's been a lot of activity in SPACs, and the idea is that you're basically investing in a group of people who will then go out and find a private company, and then that private company is joined with this special purpose acquisition company. And so effectively the SPAC was public already. So effectively it's a way of taking a private company public. There's a lot of interest now. And so that means that you get things like celebrities involved in these SPACs. On the positive side, it's great because we do want more companies to go public in the United States. And we've found that the numbers have been dropping instead of going up. And so to see a new avenue for private companies to go public is really a positive thing in my mind. But there's some other things that people investing in these need to think about. They need to understand clearly what the structure is, what the conflicts of interest are. And, the companies that are going from private to public need to be prepared to go public. Being public is very different than being private. The obligations are different. And so you have to make sure that your company is ready for that transition, no matter what method you take to go public. There are a lot of considerations to think about. And because we're getting so many of these now, our staff in our division of corporation finance is taking a look at the disclosures around SPACs. There have also been a few staff statements recently about SPACs, one from our acting director of corporation finance, and then another that he did jointly with our acting chief accountant. And those have had the effect of putting somewhat of a brake on the SPAC activity. I have some concerns about the process by which those statements were released and the relevance, certainly, of the first one to the SEC's mission. But I think that, what I would tell investors is just use skepticism here as you do with any other area. And what I would tell people who are thinking about using the SPAC model, just make sure that you're talking to the agency, that you're making the disclosures that you need to be making.
One of the other policies announced in October is the finder's fee exemption. We talked briefly about it. It's been a long time coming in terms of having kind of a policy put forward. Can you talk about the finder's fee exemption and how long that was really, as an example again of, the process that a new rule comes into play?
Yeah, so this is, I hope, not a typical example. The finder's issue is one that's been suggested. It's been suggested that we do something on it for 2 decades. And the people making the suggestion are from the small business community. Finders are people who can make introductions between people who have money to invest and small companies that need capital. And they can play a role, especially for smaller companies that may not get the attention of the existing financial markets infrastructure. We did put out a proposal for an exemptive order that would allow some finder activity to occur. It is unclear what will happen to that under Chairman Gensler, but it remains an issue that there are a lot of people who are advocating that we do something in this space. So it remains an issue that I'm interested in, because one of the perpetual issues in the United States has been that it is really difficult for small businesses to raise capital, and it's particularly difficult for small businesses that don't have, when the founders don't have easy access to networks of rich people. And so finders are a way to help us address that problem, and a way to create a legal framework to formalize some activity that frankly probably already is occurring, and that's not good for either small companies or for investors. We want to make sure that both of those groups are protected from bad actors that might have intentions other than getting capital to small companies.
This is just one proposal. What are some of the other proposals that the Commission has been working on to try to, get more access to people that are underrepresented in the capital raising system?
Yeah, I mean, the capital markets need to be able to shift capital to wherever the highest and best use of that capital is. And that means that you can't just be thinking about the coasts, and you can't just be keeping the money in any particular community. It needs to flow to anyone. So that's going to be to the benefit of the entire country, right? If you can get capital to the people who have the great ideas to build them. So there are a number of things that I've been thinking about. I mean, Finders is one. I think increasing the ability of financially sophisticated people to qualify as accredited investors who are then able to invest in private offerings is important. We have had a definition of accredited investor that's very much linked to how wealthy you are or how high your income is, but we all know that they're financially sophisticated people who might not meet those thresholds. So the SEC finally moved away from, or at least opened the door to moving away from this very stilted definition of what an accredited investor is. And so what I'm hoping is that we will allow people to qualify to be accredited investors through educational programs, for example, or through professional experience, for example. We did a little bit of that. So again, we opened the door, but we really need to open it further to allow for that, so that you can get people investing in their own communities. And these are, the people I'm trying to bring in are people who are very sophisticated. They just haven't reached the level of financial wealth that we now expect. And then another thing I'd like to do is allow for a really streamlined micro offering exemption, 250,000, 500,000, something like that, to allow people to get access, to do some sort of a notice filing with us, and then to get access to capital without strings attached. Of course, you're always subject to the anti-fraud rules, but I think that might be a way to sort of cross this chasm where small companies really need a big chunk of money, but they're really limited options to them getting it. And then that will allow them to get to the point where institutional investors would be more interested in them. So those are a few of the ideas I'm thinking about. I'm very open to suggestions about what we can do, because I do think that there's so much more possibility for our capital markets to serve a broader swath of people, both as investors, but also as takers of capital. I mean, I think it's really exciting to think about the capital markets being there, a resource that people don't even realize is theirs for the using.
I agree with you, because good ideas don't just happen on the West Coast or East Coast. And also, I would say VCs tend to be oriented to biotech and tech, but that's not the only businesses and the only type of opportunities that we have both in Canada and the United States to kind of, that little bit of flint to kind of get those ideas and kind of get them moving. This has been a really interesting talk, and unfortunately, we only have 30 minutes. And I really want to thank you for taking the time to come out and speak to everyone. We've got a lot of similarities between Canada and the United States. One of the things that we didn't touch on, unfortunately, was just how good ideas and innovators don't see borders. And unfortunately, regulators do. And, how I guess our two countries are really tied together. Canada is quite small compared to the United States, both in terms of the number of people and the dollars spent on innovation each year. But I've really enjoyed our conversation, and thank you very much for taking the time.
Well, thank you, Alex. And I just on a closing note, I will say that we've worked very closely with our regulatory counterparts in Canada. They've been just essential partners for us, both on thinking through regulation, but also on the enforcement side, which is a key part of keeping this market a healthy market and one that investors trust to put their capital in. So we're grateful for the efforts of our Canadian counterparts. Thank you so much.
Thank you.